The Supreme Court just dropped a bombshell, and it changes everything. In a stunning 7-2 decision, the justices tore up decades of legal precedent, sparking an immediate firestorm over gun rights, police power, and your freedoms. This ruling is so explosive, states are already racing to defy it. And the White House just vowed to fight back. But here's the real shocker. This isn't just about guns. It's about who controls your safety. And the legal earthquake is only beginning. Let's break it down. The case centered on whether local police can temporarily disarm someone during a traffic stop if they suspect danger. For years, lower courts allowed it under community safety exceptions. But the Supreme Court just obliterated that logic. Writing for the majority, the court declared that the Second Amendment does not vanish during a police encounter. That means officers can't automatically take your firearm just because they feel uneasy, unless they have probable cause you committed a crime. But here's where it gets messy. The dissent warned this could put officers in impossible situations. Imagine an erratic driver, hands shaking, with a visible holster. Under this ruling, police can't disarm them unless they articulate specific threats, and that's already causing chaos. Just hours after the decision, several states announced emergency legislation to work around the ruling by expanding what counts as probable cause. Now, here's what you need to know. If you're legally carrying and get pulled over, you must still inform the officer in states with duty to notify laws. But you don't have to surrender your weapon unless ordered. And now that order must be backed by clear reasoning. If they demand it anyway, you can challenge it later, but never resist in the moment. Comply first, fight in court. And this ruling goes way beyond traffic stops. Legal experts are calling it a stealth win for broader carry rights. The majority opinion hinted that any arbitrary disarmament, like at protests or checkpoints, could face new scrutiny. That's why civil liberties and gun rights groups are already preparing fresh lawsuits. Meanwhile, federal officials announced a task force to study enforcement options. Translation: they're looking for loopholes, and some senators are pushing a bill to cement this ruling into federal law, setting up a showdown this fall. Bottom line, this fight is far from over. The court drew a line in the sand, but lower courts and legislatures will battle over where it applies. And if you carry or ever interact with police, you need to understand how this ruling shifts the balance of power in real time. Because here's the twist. This decision doesn't just protect gun owners, it indirectly reshapes police tactics nationwide. Departments are scrambling to retrain officers on what constitutes probable cause now. And body cam footage is becoming the make or break evidence in these cases. In one recent example, a judge threw out charges against a concealed carrier after body cam showed an officer disarming him, solely because he was acting nervous. The judge ruled the seizure unconstitutional. That's the new standard, and it's spreading fast. But wait, there's a catch. The court left one door wide open: mental health crises. The opinion explicitly noted that officers can still disarm someone if they show clear signs of instability, like erratic speech or threats. That's why gun control advocates are pushing states to expand mental health training for police, arguing it's a backdoor to maintain safety. And it's working. Some states now require officers to complete crisis intervention training before conducting any firearm-related taps. Now let's talk protests. The ruling didn't directly address mass gatherings, but lower courts are already applying its logic. In one state, a federal judge blocked a local ordinance that let police confiscate guns at rallies, calling it a flagrant end run around the Second Amendment. And here's the kicker. Federal prosecutors quietly dropped several pending cases against protesters arrested for refusing to disarm, a sign they know the legal ground is shifting. But the biggest shockwave: red flag laws. Before this ruling, these orders often led to immediate firearm seizures without a hearing. Now, legal teams are arguing that any temporary confiscation violates the new precedent unless there's documented probable cause. One state court just agreed, striking down part of its red flag statute. If this trend holds, it could reshape similar laws in nearly 20 states, almost overnight. So what's your move? First, know your state. While this sets a federal baseline, local police might still test the limits. Second, record every interaction. If an officer demands your gun, ask calmly, Can you articulate the probable cause? That question alone could be the key to winning a lawsuit later. And third, watch the fall legislative sessions. States are drafting bills to either defy or double down on this ruling, and your rights could hinge on which side wins. Let's dive deeper into the fallout, because this isn't just about guns. It's about property rights, too. The ruling's language on unreasonable seizures is already being used to challenge civil asset forfeiture. In one case, a trucker sued after police confiscated tens of thousands of dollars from his vehicle during a routine stop, claiming it was suspicious. His lawyer argued the seizure lacked individualized probable cause, and the judge agreed. That's a huge deal, because if this logic sticks, it could blow a hole in police departments' funding models nationwide. Now, here's where it gets really controversial. This decision didn't just split the court, it split law enforcement. Police unions in some states are warning about handcuffing cops, while sheriffs in other counties are openly refusing to enforce gun laws they now call dead letters, and federal prosecutors are stuck in the middle, ordering a review of firearm prosecutions out of fear of losing cases on appeal. But the real bombshell: employers, companies used to ban guns in parking lots under state laws. Now, a federal appeals court ruled that a warehouse's no firearms policy violated a worker's rights. That's a game changer for the millions of Americans who work on private property but commute with firearms. Expect a flood of lawsuits, especially in states where lawmakers are already drafting bills to codify this interpretation. Here's the problem, though. The court didn't define where sensitive places are. Now, airports, schools, bars, lower courts are all over the map. One judge upheld a ban on guns in churches, while another struck down a similar law for being historically unjustified. This chaos is exactly why the dissent warned of a patchwork nation where rights change at the county line. So what's your playbook? First, check your car. If you commute with a firearm, your employer's policy might be unenforceable now, but consult a lawyer before testing it. Second, travel smart. Several states have already updated their reciprocity agreements, so your permit may cover more ground than you think. And third, watch federal regulators. Their proposed rules could clash with this ruling's core principles, setting up the next Supreme Court showdown. The wildcard insurance companies, they're quietly rewriting policies to exclude related incidents, calling them foreseeable risks. That means if you use a firearm in self-defense, your homeowner's policy might not cover the lawsuit. We're already seeing disputes where survivors of home invasions are suing their insurers for bad faith. Now, here's what almost no one is talking about yet: the hidden costs rippling out from this ruling. Cities scrambling to replace lost forfeiture revenue are turning to fees, annual firearms safety inspection charges, surcharges on ammunition sales. Critics call it a backdoor gun control scheme. But here's the catch. These fees might survive legal challenges because the ruling only addressed seizures, not taxes. And the biggest surprise, Ripple: divorce cases. Family courts used to treat firearms as marital assets to be divided like furniture. Not anymore. One judge ruled that stripping a spouse of their guns violated the core right to self-preservation. Now, divorce attorneys are warning clients to expect a fiercer fight over property splits. Here's another curveball: college campuses. Some university systems are reversing blanket gun bans, while private universities dig in, calling dorms sensitive places. This sets up a massive clash between schools and students, who rely on firearms for protection. Watch for a test case soon. And don't forget, renters, landlords can no longer universally ban guns in leases, but they can charge higher security deposits, which hits low-income tenants hardest. Housing advocates call it discrimination. Property managers call it risk pricing. Either way, it's a gray zone that'll take years to untangle. So what's your next move? First, audit your paperwork. If you've ever paid a forfeiture fine, you might have a refund claim. Second, pressure your insurer. Demand clarity on exclusions before you need coverage. And third, think beyond guns. This ruling's property rights angle could help you fight everything from zoning laws to vehicle seizures. Because here's the truth: this ruling didn't just unlock doors, it blew them clean off. And the people rushing through aren't just gun owners. They're tenants, taxpayers, even divorcists. This isn't a legal shift, it's a cultural earthquake. And the aftershocks are coming from the places you'd least expect. Take employees again. One factory worker won a major wrongful termination suit after being fired for keeping a legally owned handgun locked in his car. Now, HR departments nationwide are rewriting policies. Then there's social media. A collector sued a major platform, arguing its ban on private firearm transfers unlawfully restricts his property rights. The case hinges on whether social media counts as a public forum, and if the courts agree, it could force big tech to change how it handles these sales. And then there's travel. Federal screeners have been expanding random firearm searches at airports, but a judge just blocked the practice, citing the presumption against warrantless seizures. If this holds, it could reshape the agency's entire screening protocol. There's also a massive insurance loophole no one's spotted yet. Most homeowner policies exclude illegal acts, but using a firearm in lawful self-defense isn't illegal under this precedent. That means if you're sued after a defensive incident, your insurer might have to cover you. One man tested this, demanding his provider pay his legal fees after a home invasion case, and the company folded within days. And don't overlook local politics. City councils are racing to repeal old gun ordinances before they trigger lawsuits. Some are getting creative, like voluntary buyback programs that offer gift cards without confiscating weapons. Legal? Probably. Effective? Doubtful, but it shows how desperate municipalities are to avoid another reckoning. So what's the smart play right now? First, check your lease. If you're a renter, landlords can't ban guns outright, but they can require proof of safe storage, so get a lockbox and document it. Second, screen your providers. Ask upfront about any gun-related policies, because discrimination claims are rising. And third, watch your wallet. Those new gun fees might be deductible as state taxes. Talk to a professional. Because let's be real, this isn't just about firearms anymore. It's about who controls your life, the government, corporations, or you. This ruling flipped the script, and everyone from banks to hospitals to your HOA is scrambling to adjust. And once the court signals it's willing to tear up decades of precedent to protect one right, the rest are fair game. Other constitutional protections are already coming into play. Under the Fourth Amendment, a federal appeals court struck down a warrantless drone surveillance program, calling it an unreasonable search under the new standard. Under the First Amendment, a preacher sued a city for banning him from speaking near a courthouse. Even employment contracts are in play, with workers arguing that non-compete clauses trap them from earning a living. And firearm modification cases brought by tribal groups are testing both Second Amendment rights and treaty obligations. Now, here's what you need to do today. Review your contracts, whether it's a gym membership, a phone plan, or a daycare agreement. Look for clauses that restrict your rights, because this ruling might give you leverage to renegotiate. Document everything. Timestamps, photos, and witness statements could mean the difference between winning and losing. And stay flexible. The legal landscape is shifting daily, and what worked last month might not work next month. The next wave is already building, and it's going to touch immigration checkpoints, voting access fights, healthcare oversight, and even school testing rules. Lower courts are contradicting each other daily. And until the Supreme Court steps in again, the only certainty is uncertainty. This ruling isn't just a legal earthquake, it's a cultural one. It's forcing Americans to ask how much freedom we're willing to defend, and the answer could redefine this country. So whether you're a gun owner, a parent, a renter, or just someone who wants to keep their paycheck, you need to pay attention, because the next ruling could land any day now. And when it does, it won't just change the headlines, it'll change your life. So stay right here. If you want more deep dives like this, tap that like button and subscribe so you never miss a breaking update, because this isn't over. And until then, stay informed, stay empowered, and we'll see you in the next video.